Good morning to everybody. My recent book is Constitutional Governance of States in India. I will confine my lecture, today's lecture, on that subject. Whenever we speak about the state, we speak about the federalism. Because in this country where there is no states, there is no federalist. They are not federal states, they are unitary states. Because Article 1 of the Constitution says that India is the comprising with the India is union of the states. Means thereby that there are two government in the same functioning on the same territories, on the same population, and that is the characteristic of federal government. K.C. has defined what the federalism is, and one of the definition is that there must be two government, there must be two legislature, and that constitute federalism. So far as sovereignty is concerned, it is also divided in the state and the center. Whenever we say about the sovereignty, earlier the concept was that it is not divisible. But after commencement of the Constitution of USA, where 50 independent states surrendered their a part of the sovereignty in favor of United States and constituted a country, a federal country, the politicians started saying that sovereignty is also divisible. In these parameters, let us examine what is the status of our state under our constitution. There are two kinds of sovereignty, that is legal sovereignty and the political sovereignty. Legal sovereignty, in Shankari Prasad Singh's case, Shankari Prasad's case is decided by the Supreme Court in very early stage, that is AIR 1951 Supreme Court page 458. Shankari Prasad versus Union of India. This is very important case where the issues were that whether the parliament is supreme or not. One of the stand of the Union of India was that the parliament is supreme and the sovereignty rests in it. Supreme Court says that parliament is not sovereign because the Lok Sabha can be dissolved at any time by the president. And therefore, parliament cannot be said that it is sovereign. According to Shankari Prasad case, sovereignty is vested in the constitution itself. Because constitution itself has created Supreme Court, created parliament, created various organs of the states, and regulates the relationship between them. Now, let us examine the position of the state. Just I have explained what Article 1 says, that India is union of state. This indicates that our state is a federal state. But just thereafter, in Article 2 and Article 3 is very important. Article 2 says that admission and establishment of new states. And 3 says that formation of new states, alternation of areas, boundaries and names of existing states. Means thereby, even the existence of the state is depend upon the pleasure of the parliament. Parliament can divide your state into 2, 3, 4. Parliament can change the name. And therefore, when the existence of state itself is depend upon the pleasure of the parliament, how we can say that state enjoys sovereign characteristics? Not only that, only by a amendment in Schedule 1, and that too by a ordinary law. State can be formed, can be destroyed. Thereafter, Section 5 says, Section 5 is also contrary to the concept of the federalism. Because in federalism, there are two citizenships. One citizenship is citizen of union and another is citizen of a particular state, like America. But our citizenship is only one. We are citizen of India, wherever we reside, wherever our domicile is. That also goes against the concept of federalism because there is single citizenship. Thereafter, in America, citizenship is regulated by states. Article 11 says that the citizens' law relating to citizenship shall be regulated by the parliament. This also goes against the concept of federalism. Now, I take you some more articles to describe, to demonstrate the position of the state. Article 153. Article 153 relates to appointment of the governor. Governor is agent of the center. Governor represents the central in a state. Executive power of the state is vested in the governor under Article 154. And therefore, when the head of the state is appointed by the center, a state can claim that it is a sovereign state. Then governor has power to withhold legislation for the assent of the President of India under Article 200. Apart from that, there are certain legislative power which shows that so far as the legislatures, because federalism required two independent legislatures who are coordinate to each other and who acts in different fields. Here, Article 255 and 246 distributed the subjects between the state and the center. The residuary power in America is vested in the states. In case of us, residuary power is vested in this center, that is Union of India. This is also very important characteristic of a sovereign state, sovereignty of the state. Then there are 5 important aspects where in a normal situation, Parliament can make laws on the state subject. The state in any condition cannot make any law on central subject. They are Article 249. 249 says that in the national interest, the state can, the Parliament can make laws on the state list. Then Article 250 says law making power of Parliament on state subject during the emergency. Then Article 252 says that 2 or more states, they can, with the consent of 2 or more states, the Parliament can make laws. Then Article 253, whenever there is an international treaty on a subject which is covered by the state list, the power to make law in order to give effect to that treaty is vested in the Parliament. Then there is another field where the supremacy of the central is existing. Article 288(2) says that before a bill is placed Under that article, previous sanction of the president is required. 304. These are restrictions on trade. No bill without previous sanction of president can be filed, placed before the legislature. Apart from that, presently the population which belongs to scheduled caste, scheduled tribe, and OBC, they play a very important role in the development of the state, development of the nation. Article 341, 342, and 342A deals with scheduled caste, scheduled tribe, and OBC. Full power is given to the President of India to select, to find out, to trace who are scheduled caste, scheduled tribe, and OBC. Although consultation with governor is required, but power is given to the center. Then Article 352 is well known, emergency power. 356, where the constitutional machinery is unable to run, then the president rule can be imposed. These are the provisions of the constitution which makes the state weak and makes this center as a strong partner in the administration of the nation. Apart from that, there are certain decisions. Actually, without those decisions, the position of the state might have been worse. You may remember the state of Rajasthan versus Union of India. It is reported in 1977. What happened in the state? There were Congress governments. They have full majority. However, in the center, Mrs. Congress government under the leadership of Mrs. Gandhi was defeated. Charan Singh was the Home Minister. He has written letters to nine chief ministers who have full majority that they should give advice to their governor to dissolve their legislatures. That was challenged before the Supreme Court under Article 131 of the Constitution. That is the first article where the Supreme Court asserted that it has power to judicial review. Otherwise, satisfaction of the president is beyond the scope of the judicial review. Not only that, in 1998, Jagdambika Pal versus Union of India. Prior to that, there is one more case law, that is SR Bombay. In SR Bombay case, also the state of the union was there that the satisfaction of the president to impose president rule in the state is not justiciable. Supreme Court has turned down that defense. However, the order of the Supreme Court could not be implemented because new elections were taken place in 4 states which were subject matter of that case. That is Madhya Pradesh, Rajasthan, Meghalaya, and Uttar Pradesh. That these governments were dissolved when they are governed by the Bharatiya Janata Party. However, they were dissolved because of the demolition of Babri Masjid. Thereafter, another case, Jagdambika Pal came. Prior to that, whatever governor says was the final. Supreme Court says no. Sovereignty of the state should be respected. And the decision who should be a chief minister or who should not be a chief minister must be vested in the state legislature to be ascertained through floor testing. Apart from that, there is one case, very important case, that has also given the state the strength. That is Rameswar Prasad versus Union of India. In this case, a constitutional bench has entertained the issue of dissolution of the Bihar legislature even without taking oath. Bhuta Singh was governor. It was a hung legislature. He has sent an advice to the president that harsh trading amongst the elected legislative assembly members. In order to prevent it, it is better to dissolve it. And the president dissolved it. However, Supreme Court restored it. That was the first time when the dissolved assembly was restored by the Supreme Court. This enhanced the prestige of Supreme Court as well as enhanced the strength of the state. Identical case came from Jharkhand, Arjun Munda, 2005. Then there is one case of Mayawati. All these cases has given independence, strength, and dignity, respect, majesty to the state legislatures. With respect to life of this legislature, with respect to select the chief minister. I said your attention, kind attention on some of the important case laws with reference to the nature of our constitution. One case law, the oldest case law was 1951 Supreme Court, page 458. What happened in that case? In all the states, Congress was ruling party. In 1930, Pandit Jawaharlal Nehru declared about in a Lahore conference that some land reforms, that the land should belong to its tillers. To give effect that declaration, the state governments, they have enacted land reforms laws which are known as abolition of Malguzari laws. Malguzars. Malguzars, they are middlemen between the state and the agriculturists. They were removed. It was challenged before the Patna High Court, and Patna High Court in Kameswar Prasad Singh's case held that Malguzari is a property which cannot be taken over under Article 31 without fair compensation. In the meantime, the Parliament has amended the Constitution, first amendment of the Constitution. And one of the amendment was that 9th schedule came into existence. Earlier in the original Constitution, there were only 8 schedules. And 9th schedule, the law, land reforms law, which are included in the 9th schedule, exempted from judiciary. Then, in that case, it was challenged, the competency of the Parliament. We have the Union has taken a stand that alike to British Parliament, our Parliament is also supreme. And therefore, its legislation cannot be examined by the Supreme Court. In England, there is no judicial review of legislative action of the Parliament. Only subordinate legislations are subject to doctrine of alternate hands. Supreme Court has rejected this defense. Supreme Court says that the Parliament is not supreme. However, it has plenary power to enact, but that power it derives from the constitution itself, and the created cannot be bigger than or larger than the creator. Then thereafter there are cases, Sajan Singh versus State of Rajasthan. Then another case. Then Golaknath. This is also important. Golaknath was delivered by a bench of 11 judges. It has given certain doctrines like doctrine of prospective overreading. However, in Golaknath, it is held that Parliament has limited power to amend the Constitution. No unlimited power. So, Sankri Singh says plenary power. That was rejected by the Supreme Court in Golaknath. And thereafter, the First Amendment, Fourth Amendment, and 17th Amendment were declared as ultra vires. However, it is given prospective. Effect was given prospective from the date of judgment. Thereafter, in 1973, there is Keshav Bharti case. In Keshav Bharti case, it is adopted middle path. It is judgment by 13 judges. Sankri Prasad Singh's case says Parliament has as plenary power to enact the law. Yes, Golaknath says no, it has limited power to enact the law or amend the constitution. Keshav Bharti says that Parliament can amend any fundamental right guaranteed under Part 3 of the Constitution, but the Parliament cannot destroy the basic feature of the Constitution. This is a middle part, and this is still we are following that case on the theory of basic structure of the Constitution. There is one case also. That case is State of West Bengal versus Union of India. It is a 6 judges case. West Bengal has certain colleges in their state. Central nationalized those colleges. Nationalization of colleges owned by the state was challenged before the Supreme Court under Article 131 of the Constitution. Here also, the basis of the challenge was the American doctrine of immunities of the state. The state cannot take property of the central, or central cannot take property. But the Supreme Court has rejected it. And in this case, Supreme Court has held in a very clear words by giving several examples, even the mode of worship from south to north, east to west, and held that India is not a true federal state; it is a unitary state. That judgment is also very important. That is reported in AIR 1963, Supreme Court 1241. Now, I take you some things about the governors. The history of the constitutional history of India is full of the incidents where the central has used the governors to disable the state governors. And without any reasons, chief ministers were removed, assemblies were dissolved, and Now let us take the example, the status of governor. In theory, he is head of the state. Executive power of the state is vested in the governor. Governor is third chamber of the state legislature, or second chamber, as without his assent, no law can be made. I refer a book written by D.D. Thakur. D.D. Thakur was appointed as governor of the Assam. He says that the consent was not obtained from him. He says that it is his junior who has spoken to him that he has been appointed as governor of this Assam. He replied to his junior that D.D. Thakur may be some other person, because he was not able to digest that without my consent, government can appoint me as a governor. One side, central government has used or misused the governors against the state authorities. Another side says the governor themselves were misused. They were appointed except age, there is no criteria. He must be citizen of India, he must be 35 years old. No qualification is necessary. As they come without any selection process, they ghost. Whenever government wanted, they are removed. In that case, where the Supreme Court has considered the constitutional amendment of National Commission of Judges Appointment, in that there is a eminent person, and the governor was one of the member of the selection committee as eminent person. Court has raised a question whose tenure is not secured, and court has given example. When Manmohan Singh took the government, 14 governors were dismissed. When Modi ji has taken the reign, 14 governors were dismissed. And they are full of the history where the governors were dismissed when they disobey or when they are not obliged the central government. So a person whose continuance is fully depend upon the wishes of the central government, how it can be said that he is eminent person? They are transferred without their consent. Now what I take one more, because time is now running faster. Constitutional conventions. We have borrowed or followed the constitutional conventions from the England. For example, it is said that the chief minister shall be appointed by the governor. But chief minister cannot be appointed by the governor unless he is not commanding the majority in the house, elected house. Like that prime minister. There are several conventions which also again weakens the status of this. One of the conventions was that a governor shall be appointed with the prior concurrence of the state. But it is said that more than 80 governors were appointed against the are contrary to the consent of the concurrence of the state. Even without the consultation, governors were appointed. And when that happens, definitely a conflict between the elected government and the governor come into surface. to conclude my lecture, I tell you that the status of the state must be given to the status of the state. Even it was ignored when the central and state relationship was examined by Justice Jaswant Singh. In his report, it is taken care of certain field where the state is deprived to open the mouth. Thereafter, Review Commission, Constitution Review Commission has also not taken care of it. Whatever recommendation they made, they are very important and they should be implemented so that the state may enjoy an independent status within the framework of Indian Constitution and serve the people according to their own wishes. Thank you. If any question you may ask.
So, thank you so much, first of all, sir, for taking us through such elaborate provisions, and that too so briefly and in such a meticulous manner. No doubt, sir, there is a lot of curiosity with respect to, first of all, the case laws that you have shared with everyone. So, that is one question which has come to me a lot in the direct messages, that there needs to be access to the case laws that have been shared. So with respect to that, my only thing which I would want to add for everyone is that all of these videos will be uploaded on YouTube. So there will be access for everyone. Simultaneously, there is this book which sir has written very recently, which has been published also. And that same book...
It is in the press. It is in the press.
It's in the press.
Yes.
Okay, so we'll update everyone with respect to the publication of that book, and that book. Sir, if you can just share a few points about that book also, as to what has been tried to convey, what you have tried to put forward in that book to everyone, sir.
My book is divided into 9 chapters. In first chapter, I have given the status of the state by examining what the federalism is. I have taken assistance from K.C. Vere and Austin and Bentham, etc. Then thereafter, the second chapter is whether the state enjoys sovereignty or not. The third is appointment of the governor. Fourth is cabinet system. Then the legislative power of the governor, discretionary power of the governor. I have dealt those in separate chapter. Then state bureaucracy. Then apart from the state bureaucracy, I have also dealt with this all India services. The position of this speaker, money bill, everything I have included, whatever is necessary for running a state. Actually, you know, when the Constituent Assembly was considering the making of the Constitution, one of the view was that there should be 2 constitutions. One is for the union and another for the state. However, the final decision was to make one constitution covering both state as well as the union. So I tried my best to deal with each and every constitutional aspect which our states enjoy under the constitution.
I attended first time this webinar, and I especially thanks Dr. Nirmal Shukla and Mr. Keto. Really, it's very nice effort.
Thank you.
Yogesh sir, thank you so much for joining, and we hope that you'll be there, sir, because we have a series. Nirmal sir, there is something which I want to share with you also, sir,
Yeah.
and with everyone who is present. that, sir, we have through this initiative, you have, sir, also given us your time. So we have tried to get 25 different advocates from 25 different high courts of India,
Okay.
and we are trying to get the people to understand, sir, how you have elaborated the diversity of our constitution and the culture of India. So that way itself, the unifying factor of law, we are just trying to put it forward, sir, and with your blessings and with the blessings of such valued and such esteemed people who have joined us as participants also. And sir, there is Mr. J.M. Malik also, sir, Honorable Delhi High Court Justice. He is also there, sir. I welcome you, sir. And sir, so many other such people who are there. So there will be Mr. Mohit Mathur also, sir, who is also senior advocate, and he is also currently the president of Delhi High Court Bar Association. He will also be taking a class on criminal law after this. So it's just an initiative by us small children who want to learn. I would say that is how I can put it before so such people as yourself, that in these circumstances itself, sir, it's really great that sir, all of you are taking your time out and you're giving your valuable time, that too on Sundays to us, sir. That's in itself, that's great. There are a few questions also that have come. So, sir, we have a question from Miss Ishani Chauhan. So she is an HR professional, and her question is how we can get knowledge about crime and law for benefit of a company. एक कंपनी के लिए एज एन HR इंडिविजुअल वो ऐसा क्या कर सकते हैं कि उनको और नॉलेज मिले, या फिर उनका जो प्रोफेशन है और उनकी जो ऑर्गेनाइजेशन है उसको बेनिफिट मिले उससे.
I tell you, in every law where corporate responsibility is fixed, there is always a section on offenses by company. In every, because company has no mind. Company cannot be put in the jail, and therefore company cannot be prosecuted alone unless there is some natural person along with the company. One thing. The second thing is that the offenses are not committed by the companies. In fact, offenses are committed by natural person under the guard of the company. So there is a doctrine, lift the corporate wheel, lift the corporate wheel, lift the corporate wheel and find out who is working behind that wheel. Environment Act, offenses by company, director, or any person, partner, directors, whatever, who is directly linked with the affair of the company can be prosecuted as a natural person. Check bounce में भी वही है. And Mr. Yogesh Sharma is better to explain this question, being it comes within the field of crime.
Definitely, sir. So, sir, I'll just take us to another question that has come to us.
Yes.
So this question is, so it has been shared by Advocate Nilesh Sharma,
Okay.
and he asked, in what circumstances Article 356 can be invoked? Also, sir, he has another part to this question, and he asks, can reservation beyond 50% be allowed? And he also submits that according to him and his knowledge, that state of Tamil Nadu now is having about 74% reservation.
Okay. So far as the first question is concerned, that is Article 356 is concerned, it is amended, first amended by 42nd Amendment, then 44th Amendment. The discretion of the President is now limited. Safeguard is there. You cannot continue for an indefinite time. It can be imposed, President rule can be imposed when the report of governor is received by the center, and according to the report, the governance of the state cannot be in accordance with the provisions of the Constitution. Constitution machinery is failed, then only present rule is imposed. So far as the reservation of more than 51%, 50% is concerned, Indira Sahni says so that it cannot be more than 50%. And that judgment is followed by all the judgment, all the subsequent judgment of the Supreme Court. And the matter is still pending.
I thank you on behalf of everyone who is present over here, considering that you have taken your time out today, and that too on a Sunday. And sir, again, to Mr. Yogesh also, sir, for most humbly and most thankfully referring us to sir for conducting this class, and sir, you too also for such enthusiastically taking up this particular topic and taking your time out, and so for all the work and sir all the time that goes into doing this, and that too on a Sunday, sir, which is the one day that you get off. So we're extremely grateful to you for this particular occasion and for this opportunity that we have received from you.
Then
So
I gratitude to Mr. Keshav Sharma and the organizers of this webinar. Thank you for giving me opportunity to address. Thank you.
sir, thank you so much for taking this class out today. And thank you to everyone who has attended. Nirmal sir, it has been an honor once again, and I hope that we will be getting further opportunities to interact with you.
My services are always available to you.
So we are most humbled and most grateful to you for taking this time out today, and to everyone who has attended. Thank you so much.